Good afternoon, Judge Hughes.
Good afternoon, Chief Justice.
Are you well?
I'm as well as can be.
All right,
I'm just,
okay.
I'm just out of
Um,
breath.
it is well. It is well. Just relax. We're very caring people. Which of the two courts in Gauteng are you attached to?
Pretoria,
And you've been there for how long?
since 2012 in an acting capacity for 1 year, and then I was appointed in 2013.
A few of your judgments have served before the Constitutional Court. Would you want to quickly just say something about how that made you feel and how that might have boosted your confidence as a judge?
Um, it really is good when your judgments go up the ladder, and that's basically what happened in terms of my judgments. Tasima is well quoted all the time. It moved up from the High Court of Pretoria to the SCA. The SCA didn't find favor with me, but the Con Court reinstated my order, and it was on a host of issues in terms of maladministration, contempt of court, delay, condonation. So really, it lets one feel that one is doing one's duty and that one is basically exercising um, one's self-independence as a judge. It really does. The other one was Big Five and ASCA, Airports Company. That also went up, and that was in terms of dealing with making settlements an order of court, and that went through to the SCA. The SCA shot me down, but the Concord found favor with me, and they reinstated my order. And that's quite a profound one for me, because we find especially in our division being Pretoria, the hub of where all the matters come through, we find that there is quite a large amount of matters where judges just make orders of court willy-nilly, and that judgment really sets it that it's not allowed, and what's to come if one goes that route. So yes, it has been an accomplishment that I'm proud of, that those two cases have done well in right up to the apex court.
Not long after your appointment, your judgments began to surface at Constitutional Court level. I must say, so much so that the former Deputy Chief Justice asked me to appoint you to act, and I said, no, she hasn't greeted us yet, so it's too early. What did the invitation to serve or to come and act at the SCA do to you? What did that say to you? How has it, what message did it communicate to you?
The main message that it communicated to me was that, you can come from whatever walk of life, and you can make it. I say so because of the circumstances that I come from. Today, just today, is basically what I can boast about, that I could actually come this far. So having an invitation to the SCA really boosts my morale and also my esteem, and basically confirmed and fortified my view that I am a jurist. I don't have to be of any specific color or creed, but I am a jurist and I'm being recognized. And that's what being invited to the SCA did for me.
My last question, to try and make you comfortable or to cement you in your comfort zone. What is it that you believe has made you ready for the position you are applying for?
Many
You
of
don't
us,
have to be elaborate, just very briefly. This, that, or the other thing.
well, my years of experience, I'm an attorney. I've come from the realms of an attorney. I'm not a senior counsel or an advocate. I come from the realms of an attorney. I'm hardworking. And I make sure I'm diligent. I do the best that I can do. And I think I've had experience in most fields of the law, especially so being in Pretoria. Every single thing comes across your table. So I think on that score, I'm ready. I get my judgments out. I do my work. I am ready. If the commission sees that I'm ready, of course.
Colleagues, before I invite the president, may I have your names, please?
Matonsela.
Singh.
Makwanisha. Shlema.
Mlambo.
After Honorable Magwanisha, I didn't hear who was.
JP. JP.
Wait a minute.
Do you have my name?
Is that Honorable Malema?
JP Mlambo.
JP before.
I've got you here, JP. After I've got you here, Honorable Klaba. Thank you.
Kane, have you got Jenny? Jenny
Okay.
Kane?
Thank you.
Breitenbach, please, Chief Justice.
I beg your pardon?
Breitenbach, please, Chief Justice.
Okay, all right, okay. Over to you, President.
Thank you, Chief Justice. Good afternoon, Judge Hughes. It's been a long time and it's good to see you again, even if it's on the virtual platform.
Sure,
Are you well?
Yes, I am.
Are you well?
Yes.
Have you caught your breath?
Yes, I've caught my breath now.
All right. First, I want to vouch for the strong declaration you just made that you are hardworking, and we experienced that at the SCA in the first stint, during your first acting stint, which was extremely tough for you, as you were dealing with seriously ailing parents far away from home and them. And the remarkable thing, they ultimately died during that period. And the remarkable thing that I've not forgotten is that throughout those challenges, you never asked for any favors. You did not ask for time off unduly. You kept working, and you just kept you kept your nose on the grind, and you produced work. And I just found that commendable. I also want to note your long record of gender activism in organizations such as the South African Women Lawyers Association and the South African chapter of the International Association of Women Judges and other community-based women groupings. And notably, the Gauteng branch of the International Association of Women Judges, of which you are a member, is very active and does a lot of good work, especially with the young and upcoming, would-be lawyers, and that's just something to be applauded. Now, to come closer to the business of the day, you acted at the SCA for 4 terms, right?
Yes, I did.
How was your experience at the court? And I ask in this context, the SCA style of judgment is quite different from how we write as puny judges. And it's you'll agree that it's not easy to adjust to it. And you suddenly find yourself sitting in all your matters with 4 other colleagues who are going to question every word and each punctuation mark in your judgments. How did you find that transition? Did you struggle at all?
It's not an easy transition because, you know, when you presiding as a single judge, you don't have that oversight or others looking over your shoulder. And when you come to the SCA, you have that sort of a scenario. I found it helpful at times. Yes, I found it helpful, insightful, and of course something a learning curve. That's what I found. But at other times, I found that other colleagues wouldn't be so helpful like others. But you get that from division to division. It just depends on how you deal with it yourself as a person. And if you one that basically puts your head on the block and works, then you can overcome. But it is not an easy transition. The style is clearly totally different, less facts and more straight to the point, more analytic than telling a story, sort of a saga. That's what I found. The difference between writing in Pretoria and writing at the SCA.
How many judgments did you get to write at the SCA?
I think it was about, let me just check. I think it was about 8.
Mm.
I just want to double check if I can. Sorry about that.
And whilst you are checking, how were your draft judgments received by the other members of your panels, especially the presiding judges?
I didn't have many difficulties. Yes, it's seven judgments. Sorry, TJ.
Thank you.
I didn't have many difficulties, but of course you do have instances where sometimes you're not taken seriously by others, you know, in terms of your writing abilities. But ultimately, I dealt with it and I produced my judgments, and my judgments went out with the approval ultimately.
Yeah, I do recall an unpleasant incident during your second stint in 2019, I think.
Yes.
Where you tussled with a presiding judge who was extremely unhappy with your draft judgment. And as I recall, his concern was that you'd misconceived the basic criminal law principle and even misunderstood the import of a judgment upon which you relied for your reasoning. And you'll remind me, but I think the case was a simple criminal appeal, and it concerned the admissibility of dog identification, and there was this big hullabaloo about it. And you, on the other hand, were very unhappy with the uncollegial manner in which he raised his concerns. Did you find common ground with that colleague?
Well, since I've been at the SCA in that term and I finished off, I haven't been back to the SCA. But while
no, I mean in respect of the judgment.
Oh yes, okay. Well, in respect of the judgments itself, the presider was not the one that found the issue. It was actually down the chain, and it was
oh yes,
it was number 3. Number 3 had issues, and so it wasn't the presider. I'm number 5, so he was number 3, and he had issues about the issue, and he went to the presider. The circumstances were I had written the judgment, I circulated it, I waited, nothing came forward. I got a response from number 4 of the panel. And I made the necessary amendments and spoke to the person in terms of her suggestions. I waited, no response from the top 3 of the panel. And then on the last day, I think it was the Friday before you guys were going for your diversity, on the Friday, the third one on the panel came to my chambers and he said, well, I've spoken to the presider. In respect to their judgment, Wendy, I've spoken to the presider and I'm writing my own judgment. So I said, oh, so he says, yes, I just wanted to let you know. I said, okay, so you've spoken to the presider already. He says, yes, I've spoken to the presider. And he left. And then I sat and I thought about it and I said, no, man, I know for a fact, I mean, even if it's full court appeals or full bench appeals, the quorum must discuss before anybody decides to do anything outside of the quorum. I mean, that's basically courtesy. So I then approached you and I said, look, maybe I don't understand the operations of the SCA. Maybe I'm not au fait with it. Could you just enlighten me as to what the position is? Because the way things were said to me, I feel that that I'm being ousted from writing the judgment. And then you said, no, it doesn't work like this, but you deal with it. And what I must appreciate is that y'all went on y'all's diversity. We then went through the realms of dealing with the judgment, because as you said, no, continue with your judgment, carry on what you need to do with the quorum, and then decide whether you want to go with them or you want to issue out your own judgment. And I did the necessary with my judgment. We had the quorum. As a quorum, 3 of them went with his judgment. 2 of us stood on my judgment. And they said, well, there's going to be 2 judgments on the same aspect, dealing with the same issues. And they agreed with my order, but they were going to have their own judgment because they felt that I hadn't dealt with the issues that they wanted to deal with in their judgment, which they had not told me about, by the way. But be that as it may, ultimately, the judgment was handed down. After the judgment was handed down, then you said you deal with it, and you spoke to them, and they came to come and see me in my chambers. And when they came to come and see me in my chambers, they weren't very happy with the fact that I had gone to you and not to them. And I made it clear. I said, unfortunately, you 2 decided on your own without me to deal with the issue. So how did you expect me to come to you when y'all had already dealt with the issue without me? So I stood my ground, and I appreciated the fact that they knew that I was not happy with the manner in which they had treated me. You had made that known, and they had to take the initiative and come through and settle that issue with me. So I appreciate that you've done that, because that shows that you cannot just disrespect somebody else. You can't. Not in a place of work, especially when one is at work in the SCA. For the whole month, nobody goes home. So you're basically there 24 hours a day with these people. So you have to be cordial and you have to respect each other. That's basically what I'd like to say about that incident.
Well, happily, those people have retired now. I just want to find out, other than this incident, were there other occasions where you found that you were unwelcome in the court, and how was your relationship with the rest of the other colleagues?
No, other than this incident, not at all. I felt very welcome in their court, and just but for this incident that left a sour taste in my mouth, I was very happy. And I must commend them as well, because I mean, I went through a difficult period in the first time I was at the SCA, first time ever, when I lost my mom, and then 8 weeks later I lost my dad, in a succession, and I had to bury them whilst I was there. And as everybody knows now, I'm from KZN, so it was a difficult period, and they were really collegial towards me then. And I was looking to come through for the second time, as I did, to basically show them my worth, because they didn't see the Wendy that I am, because of the fact that I was going through my parents being ill and grieving, and I wanted to show them the person that I am. So the second stint, I thought it would be better, but I'm a strong person. I can deal with it.
And what happened with the rest of your judgments? Did they go through smoothly?
Now, all of them, yeah, all of them, the other 6 went through very smoothly. Thank you.
All right. No one questioned your intellect or or worth to be at the SCA.
No, no one did.
All right. Now, I raise these issues as a precursor to my next question, which is a comment by the GCB, which raises a number of concerns about your competence as a judge of appeal. They take issue with the quality of your legal reasoning and writing, your ability to discern the material issues in the case, your understanding of basic principles of civil procedure, your writing style and inability to follow a logical structure, and even your command of the written English language. How would you comment to these criticisms?
You know, with regards to the comment, it's the opinion of the GCB, but my judgments were at the SCA with those who work at the SCA. If there was issue with those judgments, you would be sitting today with comments from those judges who I sat with. I can't take it any further. There are instances where one is not perfect in the English language. One could say it better. One could have written it better. One could say that. But in those judgments that they point out, they go through a host of judgments that I've done. And out of the host of judgment, they pull 3 or 4 out. And out of those 4, they then extrapolate from the 4 the paragraphs that they feel are not up to scratch in terms of the English language and or phrases used by myself. One can do better. One cannot say that one can't do better. One can do better. But in these circumstances, those judgments went out. They went out to the attorneys. They went out to the parties. They went out to the council. None of them have come back that we need leave to appeal because the judge didn't know what she was doing. We can't understand her. We can't discern what she's saying, as they have said in their comments. So that's basically what I've got to say about the complaint. But I'm humbled that they even took the time out to make a comment.
So in sum, you say you're good enough for the SCA?
I think I am, and I assert that I am.
Thank you, Judge Hughes. Thank you, CJ.
Thank you, President. Advocate Madonsela SC.
Thank you, Chief Justice. Hi, Wendy.
CJ, Mr. Madonsela is far from his mic, I think.
Good afternoon, Judge Hughes.
Good afternoon, Commissioner.
I should start by saying that I long for the day. I'm longing for the day when we can sit in judgment and judge the linguistic proficiency of English speakers when they have to write in Zulu or any of the vernacular languages. I'm longing for that day. But that's not my question.
Commissioner Madonsela, I appreciate that, but let's cut down on preambles, please, so far as possible.
The question is this. I would like you to recount how it came about that when I started at the bar, you were the only person ever who managed to brief me on a Transnet brief, ever. And I've never seen it since you left. What did it take for you to do that and transport me and ask me to come and argue a matter in another division in Joburg? And it has never happened. And what is your experience about the appearances of black counsel before you as a judge in the courts where you have appeared?
Okay, well, just full disclosure that the commissioner, Madonsela, started off at the Durban bar, and my firm is proud to say, well, my firm that I had is definitely proud that we've taken you so far, and I congratulate you. But being that as it may, let me move on. In terms of instructing counsel, I did my articles at a firm called Mlaba Mackay and Partners, and we did mainly political work. We were sponsored by SALDEF in those days, and you only encounter those counsel who are thrown and shunned by the wayside, that are prepared to come and do pro bono work. So my entire ethos when I formulated my own practice was to ensure that I did pro bono work. And in doing so, you actually enhance the pool of those advocates who are not briefed by the so-called big firms. And in doing so, you also enhance yourself and themselves to enhance others. And in the Transnet matter, we were instructed by, of course, in those days, it was only the white legal advisors, and they were of the view that I should instruct X, Y, and Z. And I said, no, I've got somebody who's competent. He can do the work, but it's in Joburg. I said, we'll come up to Joburg. We'll find our own way to Joburg, but we'll get there. And we won that case, and we did well. And thereafter, they trusted me in terms of my judgment of who to appoint and when to appoint. I also had the opportunity myself to also impart the little skill that I had picked up along the way working with my client to actually guide my counsel so that he doesn't disappoint my client, and that we empower each other as we fight the fight of trying to make sure that we try to do work together so we can move out of the realm of not having work, you know, as black counsel and as black attorneys.
Thank you, Chief Justice.
Thank you very much, SC. Advocate Mpofu SC.
Thank you. Good afternoon. Is it still afternoon? Good afternoon, Church.
Afternoon,
Thanks.
Commissioner.
Good to see you again.
Oh, nice to see you as well.
Yes. Look, I don't even want to waste time about the issue that Mr. Matansela was talking about on language. As you know, I'm one of the representatives of the GCB. So the protocol prevents me from commenting on some of those issues.
Understandable.
So but I can just assure you that that is not the view of all persons like Mr. Madonsela, who are part of the GCB. But be that as it may, I thought maybe I'll just talk about my own personal experiences, particularly on this language thing. I remember specifically, and I'd like you to comment on this. One of the cases which we appeared before you, I think you were sitting with the JP on a full bench, one of the most important cases in the history of this country, which was the President versus the Public Protector, without which there would be no Zondo Commission today, if we had not argued that case successfully. Yes. Sometimes it gets forgotten. But in particular, the reason why I'm raising this is because I was just going through the judgment now, trying to find the passage, but I can't find it. But I remember specifically that one of the issues which was decisive in that case was the difference between, you know, sometimes cases can turn on a small thing. It was the difference between the and a. And I remember when we argued this, you were it's in the judgment, but you are the first person who picked up that point. And every time the counsel from the other side came up, you were saying, but it doesn't say they, it says a, and so on. And that was a pivotal issue in the argument that we had advanced. Now, if somebody who can dissect a matter at that level of that minute level of the Queen's language, then I find it a bit strange that you are accused of being bad in English. I just wanted to know firstly whether you remember that, and whether in your general experience of interpretation, you've ever struggled with interpreting statutes in their English technical sense.
Well, in terms of the memory, I remember that. I think even the JP can attest to that, because that was brought out in our consultations, prior, and that was advanced by me. The JP can attest to that. In terms of interpretation, if you look at the list of judgments that I've put up, or you've appeared in my court and I've delivered judgments for you, you would know that most of the work that I get allocated is technical interpretation, statutes, civil litigation, custom and exercise, interpreting clauses, interpreting legislation. Most of the work that I get is that way inclined. So in all the more than 300 cases that I've been doing, I feel that I do so adequately, and I've had no problem with doing so. That's basically it.
Thank you very much. Yeah. And then on a separate but maybe a related topic, I also appeared before you in a very complex intellectual property matter. And in my experience, the judgment was delivered promptly. It was more than technically good. I think I was partially successful. I can't remember.
Yes.
Yes, I can't remember the outcome. But the point of the matter is that for someone like you and me, this was a field that was not, our daily bread.
Yes.
But obviously, when the work is there, it doesn't matter how complex it is. We had to navigate through it, and I think it was against the people who fancy themselves as, as the specialists in those areas. The real question is, how do you, rate the question of application for a judge or counsel for that matter? Because nobody can be familiar with all areas of law. It doesn't matter whether it's competition law, intellectual property, or criminal law, or whatever it is. What does a judge have to do when confronted with an area which may not have been their specialty of practice, or a completely new area, which I'm sure has happened to you?
Well, my modus operandi is that, and I knuckle down and I read my file. I make sure I do my reading. Having done my reading, then I do my research. One just needs to research. Once one has researched, then one questions oneself, and that in turn helps you to ultimately find the answer. So I regard it akin to when you start varsity. You've never ever had a law of contract when you were in school. But when you get to varsity, you listen to the lecture, you do the research, you go to the exam and you write the exam, and then you get sum cum laude or cum laude, or you get B, C, or whatever. So it's likewise, if you've got that passion in you to research, then you can overcome any aspect of the law that you're not familiar with.
Thank you. Thank you, Sija.
Thank you.
Thank you, Commissioner Mpofu. Commissioner Matolo Zepu.
Thank you, CJ, and good afternoon, Judge.
Good afternoon, Commissioner.
Right, one of the things I love about our female colleagues, especially judges in Gauteng division, is their sisterhood, you know, and their willingness to train mentor young female legal practitioners. But what I want to find out from you is, in your experience, are there a lot of young female attorneys appearing before you? And if not, what can be done to encourage and upskill them to? Because I'm really proud of attorneys who are judges now, like yourself. But I still feel that we need to do something extra, you know, to upskill them, to appear and not depend on
Counsel.
advocating officer.
With the upskilling of attorneys, I think attorneys should take time out to observe. You know, they need to take time to observe first. Come through and observe, and it's difficult because you're running a practice, but come through and observe, because once you observe, the phobia is gone. The scare of being in the court realm where advocates are, sulks are, flies through the window, because you've observed what they do, and then you realize that in fact I can do this. So mainly observing, and also issuing work to advocates that you know are going to enhance your skill. They're going to enhance your skill. You brief your advocate, he does the opening, he does part A, and he says, the attorney who has right of appearance is going to argue on the cost, which is a small portion, but it's part B. You empowered. You empowered. The judge knows you. You have basically shown your worth. So that's basically what I would suggest or recommend that could be done, if it helps to answer your question.
Yeah, I just a follow up. I know that you are part of the female judges who participate in workshops,
Yes.
you know, empowering female attorneys. I'm worried that if we have to take you to Bloemfontein, will I be able to get you again to come and train?
Well, the JP has a training platform of training aspirant judges, not only from the bar, but also from the magistracy and from the fraternity of attorneys. So if you would maybe keep in contact with the JP, he could give you dates on when they go through and do the necessary trainings, and that's how you can still keep in touch with judges like myself.
Thank you, CJ.
Thank you.
Thank you very much, Commissioner. Commissioner Tsepe.
Thank you, CJ. Good afternoon, Judge.
Good afternoon, Commissioner.
Judge, I'll ask one question because the other has been covered.
Okay.
Judge, my question relates to a comment from the GCB relating to commitment to the values of the Constitution. The GCB says there's nothing in your application or history that answers this question. So I wanted to then ask this question of you, that as you know, the Constitution requires courts, when interpreting any legislation, when developing the common law and customary law, to promote the spirit, purport, and objects of the Bill of Rights. Can you point to cases that you wrote that reflects your observance of this obligation?
The same GCB made mention of the case that I made reference to in respect of the same comment that you're seeking, and that was in Center of Child Law versus Media 24, where basically it dealt with the interpretation of dealing with child witnesses, child victims, and child accused. And it went all the way up to the Constitutional Court. So that's my answer to your question.
Thank you, Judge. Thank you, CJ.
Thank you, Commissioner Tsepe. Honorable Singh.
Thank you very much, Chief Justice, and good afternoon to you, Judge Hughes.
Okay.
I'm on the screen.
Okay. Okay.
Thank you. I think it's quite a coincidence that today we have had two judges appearing before us, Judge Carrols and yourself, both ex-Durban, having schooled in Durban, and you know, both of you are applying, both of you are alumni of the University of Durban Westphal, and both of you are applying for positions to the SDA. And I can also relate to the area you come from, because I'm also a Durban boy, although south of Durban, but a bit of a rural area. But my question, Judge Hughes, and I'm very proud of your growth.
Thank you.
My question relates to your career path in the judiciary. Because when I see in your questionnaire, you acted as a judge in 2009 in KwaZulu-Natal. But thereafter, you know, you went to the Northern Cape for 2 years, Pretoria, acting judge, then Gauteng, and then Pretoria, and then even a stint in the Lesotho High Court as an acting judge in the Constitutional Court Division. Could you just elucidate on what gave rise to these moves? Is it the fact that you didn't have opportunities in KZN, which is your home province, or any other reasons? Thank you.
To answer you on that question, in 2009, I started my acting stint after I'd finished the aspirant women's judicial training. And then I was invited by one of the conveners of that course, JP Homo, to be mentored in his court. And then I took that leave and I went to Kimberley, and I was mentored in Kimberley. Thereafter, I got an invitation. I got an invitation from JP Mlambo to come through to his court, because he had basically heard of my work in Kimberley, and that's when I got through to Pretoria in 2012. On all those occasions that I moved to Kimberley, to Pretoria, it was by invitation by the relevant JPs, who basically saw the potential in me, and they basically invited me, and I basically put my hand up and I went through. In respect of the Lesotho acting appointment, we were seconded, Colopin, Judge Mahoka, and he's in the SCA now, and myself was seconded to deal with an issue on a constitutional matter in Lesotho, which dealt with the impeachment of the Chief Justice at that time. That's how I got to preside in a matter in Lesotho.
Thank you very much, Judge. CJ, what I've learned today is that even the JPs go on a fishing expedition to catch the best fish for their courts. So thank you for that. Thank you very much, Chief Justice, and thank you, Judge.
Thank you, Honorable Singh. Thank you, Honorable Magwanisha.
Thank you very much, Chief Justice. Good afternoon, Judge.
Good afternoon, Commissioner.
And my condolences on your loss.
Oh, thank you so much. Appreciate that.
No, I have only one question for you. You are a judge of a very active court with a lot of workload. How has the case line assisted the judges in that division to make your work much easier?
Oh, it's heaven sent. You just can't understand how our lives have been made so much easier. We deal with very complex matters where you're carrying around maybe 100 to 80 lever arch files if you're dealing with it physically. But in this instance, this is the first portion that I'd like to deal with. In this instance, everything is on case lines. It's uploaded onto case lines. You're in the comfort of your study. You read whenever you want to read. You don't have to now say somebody hasn't put the file on your table. Everything is logged onto case lines. It's really made life easier. It's also made our lives easy in the sense of delivering of judgments. There's no delays that you need to look for a court, or you need to ensure that you assign a day that you'll deliver the judgment, because electronically, today I finish the judgment. Tomorrow morning, when you get to your office or your chambers, it's electronically delivered in terms of the protocol. So it makes things much simpler. More so, with the comorbidities that we have, and with the situation of COVID, you're able to work from home for like most parts of the lockdown, especially the serious lockdown, where you can't basically give justice to others by going to the court, you are able to do so from the comfort of your study, or if you don't have a study, from the comfort of your bedroom. You're able to do that. So that's how much easier it has made life for the judges. I was just speaking to a colleague of mine, and he was saying that he's in this investigation unit, and he was saying it's so difficult because they're not on case lines, and he's lugging around files, and life is so much difficult. I don't know how we'll manage without case lines.
So if you are appointed to the Supreme Court, you will miss it.
I will. And I might have to advocate that they get it.
Thank you very much. Thank you, Chief Justice.
The SCA is on case lines. Thank you, CJ.
Thank you, Honorable Magwanishe. Thank you. JP?
Thank you, Chief Justice. Judge Hughes,
yes.
You were referred to some judgments in the GCB comments where you could have got things wrong. Is it not correct that in your life as a judge, you'll get certain things wrong?
Yes, you would. Yes, you would.
And it's not because you're stupid or you don't apply yourself. You will, it's a human trait, you'll get things wrong sometimes.
Yeah, well, clearly it has been indicated in this forum that even those who have the acumen from abroad can even get things wrong.
And is it not correct too that in your life as a judge, you can never start your career as a judge and retire as a judge without having been reversed on appeal?
Oh, you have to deal with that. You have to deal with that because it's part of the makeup of being a judge.
Yes.
Just like you have to deal with when somebody comes through and they say, we want leave to appeal. And we say, you erred or you misdirected yourself. It's part of the makeup of being a judge.
Yes. I think, CJ, one last question, sorry. Your experience of number 3 talking to number 1 and coming with things, you join some of us who've been there. Number 5, who was an acting judge, got through to number 1 to criticize a judgment that written when I was permanent and when I was number 3 without talking to me, and circulated a judgment without talking to me. And when you look at it, Justice Siriti will tell you, as you said, it deals with the same issues, same facts, same conclusion. But simply because number 5 has got an English name, you are going to be forced to try and adopt that draft. You join that club. Thank you, CJ.
Thank you, JP. It looks like you might just be an authority on the top 6. I think I need to talk more to you.
Yeah,
Honorable.
I agree. Chief Justice, thank you. I'm covered. Thanks, Chief Justice.
Thank you, Honorable Klaba. Advocate KNSC.
Thank you, Chief Justice. Good afternoon, Judge. Sorry, Judge, are you able to hear me?
Yeah, now I'm able to see you and hear you.
Yes, good afternoon.
Good afternoon.
What has been so evident from your interview is a comment made by the GCB, which is a report back that you are pleasant in court and that you engage actively with counsel. You put your views to them and you give them a proper opportunity to respond. And frankly, that's just such a fantastic review and report of you and the type of interaction that counsel really value in court. I just wanted to commend you on that.
Thank you.
In relation to the GCB review, many of my colleagues have taken up what is said in it, but it pertains mostly to quibbles about your language, and I don't want to take that up. What I would like you to deal with, if you could, and just have a look at it, the JP has suggested it may have been an error, but in the I would say the criticism against you and the main thrust of it is that in a review application, you dealt with one ground of review when there were others that also required to be dealt with, and perhaps overlooked the other grounds of review. Now, given that correction on appeal and so on, is there anything you would like to say about that?
In respect of that matter, I would like to say that the aspect that I dealt with was a jurisdictional aspect, and I found that it was dispositive of the entire review. That's the stance that I had taken. The issue of me not dealing with the other elements of the review, in my view, when I dealt with the review, did not fall within the realm of a review because they weren't raised with the committee before. So when it went to the SCA, I acknowledge that the SCA says I should have dealt with them because one of them could have been successful for the applicant. I acknowledge that. However, I also want to point out that in terms of the issue that I dealt with, the applicant did not take issue with that on appeal. So that issue was clearly good enough and stood. And that's basically what I'd like to say about that. But I acknowledge that the SCA has made a pronouncement on the manner in which I dealt with the matter.
Thank you very much. Thank you for that answer. Thank you, Chief Justice.
Thank you very much, Commissioner. Honorable Minister.
Thank you, CJ. I'm covered.
Thank you very much, Honorable Breitenbach.
Thank you, Chief Justice. Good afternoon, Judge.
Good afternoon, Commissioner.
Judge, there's a perception, or there's a reluctance or a perceived reluctance by members of the judiciary, including the magistracy, to deal with matters of rape, sexual violence, gender-based violence. In your view, what can be done to address this matter?
You know, some colleagues of mine, we had some discussion in respect of dealing with criminal matters across the board, not only with rape matters, but criminal matters where there's gruesome deaths and there's hijackings and there's incidents of you know, molestation and the like. And we said, you know, maybe we should instill some debriefing and or a sense of trying to have an opportunity to speak about how we handle matters of that kind in our courts. But what I've noticed is that wherever you are deployed by the JP, you have to go and deal with it. It is more so that those who have a civil background shy away from that sort of work. But the JP makes certain that everyone who is a judge must do all spectrums of work, especially so in the Gauteng division. You can't shy away from the work. But I get that there are those who don't want to do that work. But unfortunately, you decided to basically work for the public, so you're going to have to put your issues aside and get on with the work. That's the best answer I can give you.
Thank you very much.
Thank you, Judge Hughes. You are excused, ma'am.
Okay, thank you. Thank you to the Commission for having me, and thank you, Chief Justice. Thank you, Commissioners.
Thank you.